Hello, and welcome back to Elise Explains IP, the podcast where we break down intellectual property concepts into practical, real-world insights for business owners, founders, and brand custodians. I'm Elise Dijkstra, and today we're tackling a question that I get sometimes. If I use a foreign word as my trademark, does that make it distinctive? Short answer, not necessarily. But the long answer, and like most lawyers, it depends on whether that foreign word is descriptive under Australian trademark law. And that's exactly what we're looking at today. So let's start with first principles. In Australia, a trademark must be capable of distinguishing your goods or services from those of other traders. That's the core test under the Trademarks Act, and you can go back to episodes 2 and 5 for more information about them. A mark will struggle for registration if it is descriptive, directly referential to the goods or services, or commonly used in the relevant trade. And importantly, that test also applies if the word isn't in English. There's a common misconception that using a foreign language automatically gives you something unique or registrable. The Australian Trademarks Office and the courts don't always see it that way, although there's an interesting quirk that I think is quite unique. So how does Australia assess foreign words? The key question is whether the ordinary Australian consumer or the relevant section of the public would understand the meaning of that foreign word. To the average consumer would recognise the language and readily understand the meaning, then the word may be treated as if it were in English for the purpose of assessing descriptiveness. This is particularly relevant for commonly spoken languages in Australia, widely understood culinary, fashion or lifestyle terms, and industries where foreign terms are commonly used. So let's look at some practical examples. If you were to attempt to register Mercato for supermarket services, Fresco for fresh food products, or Bella for beauty services, the examiner will ask, does this simply describe the goods or services to someone who understands the language? If the answer is yes, then the mark is likely to be considered non-distinctive, even though it's not English. In food, fashion, wine and hospitality in particular, foreign words, especially Italian, French and Spanish, are often well understood by Australian consumers. But again, there's an interesting twist to this. That said, foreign words are not automatically doomed. A foreign word may still be registrable if it is obscure and not commonly understood in Australia, if it has no clear descriptive connection to the goods or services, or if it is used in an unexpected or arbitrary way. Again, we've talked about using, say, Amazon for a shopping service. And it doesn't even have to be that obscure a language. A pivotal Australian case that all brand owners should understand when considering foreign words as trademarks is Cantarella Brothers Proprietary Limited and Modena Trading Proprietary Limited, decided by the High Court of Australia in 2014. In that dispute, Cantarella, an established coffee importer and retailer, owned registered trademarks for the words Oro and Cinque Stella, used for both on coffee products, both Italian words meaning gold and 5 stars respectively. Modena Trading challenged those registrations on the basis that the words were not inherently adapted to distinguish Cantarella's goods from other traders. In other words, Modena argued that because the words could be understood in Italian as descriptive of the quality of the goods, gold or 5-star coffee, they should not have been capable of functioning as trademarks. The full court of the Federal Court initially agreed with Modena and held that the marks were descriptive and couldn't be registered, and should be therefore removed from the register. However, the High Court of Australia, on appeal, determined that by majority reversed that decision. The High Court held that the test for whether a trademark is inherently adapted to distinguish applies equally to foreign word marks and English word marks. There is no special, extra, separate test just because a word is not in English. What matters is how the relevant words are understood in Australia in the context of the goods and services concerned, not simply their dictionary meaning when translated into English. In this case, the evidence did not establish that the Italian words oro and cinque stella were so widely understood by Australian consumers of coffee that they would be taken to be directly descriptive of the product's character or quality, and that there was insufficient evidence that rival traders needed those words in order to honestly describe their goods. As a result, the High Court held that the marks were inherently adapted to distinguish Cantarella's coffee products and should remain on the register. The Cantarella Brothers case is important because it reinforces that distinctiveness must still be assessed under the Trademarks Act's ordinary tests, even for foreign words, and it clarifies that merely translating a foreign word into English and finding it descriptive is not sufficient to deny distinctiveness if the relevant Australian audience would not treat it as directly descriptive. There's a very interesting follow-up to this case that was recently decided last year that we'll talk about in another episode. But for now, in relation to descriptiveness, that's where we can leave it. Context matters, audience matters, industry matters. This isn't just a legal technicality, it is a branding risk issue. If your mark is descriptive in whatever language you choose, registration may be refused, enforcement becomes difficult, and competitors may be free to use similar language. I see businesses sometimes invest heavily in branding built around a foreign word, only to discover later that it can't be registered or that it offers very narrow rights. And that's an expensive lesson. And let's ask Lavazza and Cantarella Brothers about their ongoing and long-running court battle over that Oro trademark for coffee. This is exactly why a trademark clearance search and a brand strategy should happen before you launch and before you invest that money. If you're considering a foreign word as part of your brand, I would strongly recommend a proper clearance search and a strategic assessment of whether that word will actually function as a trademark in Australia. If you'd like to book a strategy call with me, you can do so directly through my website, elisesteekstra.com. I also have a free IP audit tool available for download, which is perfect if you're kicking off the new year by reviewing your brand, content, and IP assets more broadly. If you found today's episode helpful, make sure you subscribed to Elise Explains IP and feel free to share it with someone who's currently naming a brand, a business, a product, or a service. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.